number 114, the people of the state of New York versus Marianne Grady Flores. Good afternoon, counsel.
Good afternoon, Your Honor. Lance Salisbury on behalf of Appellant Marianne Grady Flores. I'd like to reserve 2 minutes for rebuttal, please.
2 minutes, sir.
The central issue in this case is the invalid order of protection.
Mr. Salisbury, we recently decided People versus Smith,
Correct, Your Honor.
and we held that the filing of an affidavit of errors is a jurisdictional requirement.
Correct.
How do we get by Smith here?
This is a pre-Smith case. This appeal began percolating before Smith. At the time of this case, the law was in a state of flux. That's reflected in the record here. You see, appellant was relying in fact, upon the OCA, the 2008 OCA memo, in the instructions from the town court, which indicated you should not file.
That happened in Smith too, didn't it?
It's a little different here in that, in this case, appellant went beyond in a motion to the county court and indicated we are following the case law and everything at the time that indicated not to, and requested, if this is incorrect, please instruct us and we will go back and file the affidavit of errors.
If we were to find Smith applicable here, is there anything that Ms. Flores could do to have her appeal heard, to extend the time or anything that you're aware of?
Yes, you'll notice under, I believe, CPL 460, there's a 1-year time period for cause where you can go back and file the affidavit of errors. Here, in that motion, that was filed well within the 1-year time limit. The appellant specifically requested permission to do that. The county court did not entertain that motion, remained silent. The respondent remained silent, I think, which goes to the matter of the issue of flux, so that if the court was to so determine that, I think you could remand to the lower court, one, to allow the filing of affidavit of errors pursuant to that, and then, I guess in terms of judicial efficiency, follow, then implement the findings of this court on the merits of the case.
Just to clarify, is your position then that the motion that you're talking about is filed within that 1-year time frame, but that the court never decided the motion?
The court remained silent on it. The court never answered that motion. The appellant sought, we raised that issue and laid out the arguments of how we thought we were proceeding correctly at that time.
So you're suggesting if the court views Smith as an obstacle you cannot overcome, that since that motion is not decided, it should be remanded for a decision on that motion? Is that what you're?
Well, I think clearly, yes, that the time period allows for the party to go back and file the affidavit of errors. And here, clearly, given the state of flux the law was in at that time, and we would argue it was more a procedural matter at that time, had not yet been determined to be a jurisdictional defect, that yes, the appellant has to be allowed then to remand to file the affidavit of errors.
In county court, did the people object on the grounds that the affidavit of errors was absent?
No, Your Honor. The first time they've raised that objection is here at this court.
Go ahead. Go ahead. Let's talk about the First Amendment.
Okay. This order of protection does implicate the First Amendment rights of the appellant. The overly broad nature, the vague nature of the case, of the order of protection, rather, implicates, when we look at the Supreme Court in McCullen in Schenk and Madsen.
Talk to us a little bit about the order itself. Does the order identify a victim?
Well,
Because it refers to Colonel Evans.
It refers to Colonel Evans, but I think we find the rationale for the order of protection was Colonel Evans' supporting deposition. And in that supporting deposition, he doesn't seek an order to protect himself. Indeed, he discusses the demonstrations that have occurred, at the base gates, and then he states, as the authorized representative of the base, I'm seeking the order of protection to keep the demonstrators away from the base.
Was there any specificity in the order at all?
No, there was no.
If you compared the order to any of the Supreme Court cases that have applied similar situations where, particularly with abortion rights protesters.
Right. I think you see there that this order of protection would clearly fail as being overbroad and vague on those grounds. If you look at Schenk, there the court overturned the floating buffer zone, but it held the permanent buffer zone a space of 15 feet from
Right.
the
But
driveway.
there was specificity in those cases.
Correct, Your Honor.
So, counsel, the order of protection directed Ms. Grady Flores to stay away from the property.
Right.
She was arrested on the driveway?
She was arrested on the shoulder of the roadway, adjacent where the driveway meets the. Well, I'm sorry. Let me correct myself. She was not actually arrested there, Your Honor. She was arrested some distance away.
For being there.
For being there, being on the shoulder,
Right.
taking photographs, Your Honor.
So I thought that it was actually on the property of the base, is my point.
Well,
There was an easement. I know there's some discussion about the
Right.
easement. My question to you is, if she was arrested on the property there, does that limit your First Amendment argument
no.
in terms of it being overbroad because the order directed her to stay away from the property and if she was in fact arrested on the property? Does that narrow the argument?
Not sufficiently, Your Honor. And I think particularly here because of the confusion over the base boundaries. And you see the instructions of the trial court had given definition, sought to give some definition, where you see it in the supplemental appendix, I believe in page 12, where the trial court agreed with trial counsel that she at that time had a definition of if she was in the roadway, she was adhering to the order. As the trial court gained more information over the course of 2014, that definition changed. You see at the end of the case.
Counsel, I'm sorry, you're almost out of time, but a little bit differently. They have this order of protection. In those cases, Schenk and some of the others, you get the order, they appeal it as overly broad, it goes up to the Supreme Court. Here, she's accused of violating it, right? Is there an obligation to have challenged the order initially? I mean, do we want people who have order of protection, let's say it's an assault, and then you claim in the assault case, it was overly broad. Sorry.
To answer your question, Your Honor, the appellant did object. I believe there's enough material in this record for you to make that valid inference. You see, for instance, appellant went so far as to be one of a group who filed an Article 78 action from the underlying case against the order of protection. When you read the record here, you'll note that the prosecution never raised an issue of lack of preservation and even noted at trial that following arguments on the motion in the court's decision, that matter was now reserved for appellate argument.
No, I understand the preservation argument in this case, but my other concern, I guess it would be, is can you really wait and challenge it, or in this case you lose on a challenge and then you're accused of violating the order, and then you say, no, the order isn't any good. I mean, those cases like Schenk, they appealed the order and said it's unconstitutional before they were arrested outside of the clinic or wherever it was. This case, you're arrested. You should have challenged the order before. Do we really want people coming in and challenging protective orders and all after they violated them, or is that a challenge you should make directly?
Well, I believe there was a challenge made directly at
And why doesn't that bind us here, or the
Well,
court here?
It was
You lost.
never answered. I believe if you look in the supplemental appendix at page 20 and then pages 24 and 25, you'll see at oral arguments on motions in this case, there was discussion on the fact that the trial court had not yet decided the motions made on the October 2012 case. So there had been no decision.
So it was pending?
It was
That's
pending.
what we're talking about, it's pending?
Pending.
So there's no decision on whether this was a valid order or not?
Correct.
Since then, though, there has been a decision on this, hasn't there? On this type of order? I thought that Onondaga County had dealt with another defendant in a similar situation.
That's correct. The Judge Brunetti decision, a Supreme Court on exactly the same type of order had determined that it was overly vague and invalid on many of the same grounds that we're raising here. So it had been addressed subsequently.
Well, Mr. Maxwell will have something to say about that.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, excuse me.
Good afternoon, sir.
Please, the court. If I may, I'd like to pick up on that last thread, just to start. In one of the amici briefs, there was a reference to Walker versus City of Birmingham, that's in 388 U.S. 307, that talks about that, just challenging it. And here, it's hard to piece together everything, but it seems to me that most or all of the complaining about the order of protection happened after this arrest. The October issuance of the order, followed by the February violation of the order, and then going to, in our case, Justice Gilbert in an Article 78, and he denied it. So there was a conflicting Article 78s.
Well, that's basically a preservation argument, though, and it seems pretty clear that they brought this up in the omnibus motion, so it seems to be preserved. Now, could it have been done better? Sure, but, you know, the more interesting point, there's two things. First is the point that Judge DiFiore brought up, and Judge Wilson also mentioned, is the county court didn't rule on the motion because that jurisdictional problem is a stumbling block here, I think, for us to get into the secondary analysis.
Yeah. On the Smith case analysis, I admit I've been bothered for years waiting for you to come out with that decision because every time we do a lower court appeal, we're scrambling. And getting the Smith decision around the same time we got the leave
It
granted.
was the same day.
Yes.
The Smith decision came out on the 23rd, I think, of June, and that was the same day that I signed the CLA. Yeah.
And I brought it up in the brief because at that point I thought I'd be foolish not to.
But so that is the first time you brought it up?
Yes.
You didn't bring it up in the county court?
I don't think I brought it up in this case. Other
Does a
cases we talked
jurisdictional
about it.
defect require you to bring it up in the county court?
Oh, no, of course not.
No. The only question really is that apparently the defendant brought this issue up and it wasn't ruled on.
I have to be honest, Judge, I don't remember.
Oh, okay. That's
I
no
can't help you with whether
That's
he
no
brought it
problem.
up.
Mr. Maxwell, let me direct you to the accusatory instrument in which it's alleged that Ms. Grady Flores violated a duly issued order of protection, whatever the language is. Was the order of protection attached to the accusatory instrument? I'm struggling to find where it is that it's alleged that an order of protection was actually in effect, she knew about it. I don't see that anywhere.
Well, what I recall, Your Honor, is that the order of protection was issued in October. Even at trial, she testified that she knew it was issued.
I'm talking about the accusatory instrument and the sufficiency of that charging instrument.
Again, I don't remember if we physically attached it. I just don't see a serious issue of lack of notice. The accusatory instrument.
I think the question is really directed to the facial sufficiency of, under Alejandro type analysis.
I believe.
I don't remember the CPL section. It's 100 point something.
45, maybe, but I
40,
40.
1B.
I believe we issued an accusatory instrument that clearly referenced the order, that the order was, it's a routine stay-away order using the Office of Court Administration form, and stay-away is the words of the statute and the form. She was on notice. The accusatory instrument charged her with both crimes, or both with the crime and the violation. and it charged her with being in the driveway. Sergeant Ramsey talked about her being in the area where the other group was, the people were actually protesting that day on the north side of Malloy Road, so that she was, again, in this mouth of the driveway. When we talk about boundaries of the base, I think that gets us off track, because I think stay away was appropriate here.
But if we apply Marsden and Schenck in those cases, doesn't this order burden speech more than necessary? I mean, couldn't it have been more limited to not blocking the entrance or staying, with so many feet from the entrance, or not being disorderly? I don't know. It just seems that this is about as broad as you can get when it comes to First Amendment rights.
I agree, Your Honor, that it could have been worded any number of ways.
But Mr. Maxwell, it sounds like a domestic violence order, not a First Amendment speech order. I live about 5 blocks away from the abortion clinic where the Schenck order came out of. And I remember going to work every day, and there were lines on the street that had been actually painted there to tell everybody where to stand, so the court could supervise the effect of the First Amendment. And then when people violated those orders, trespass charges were brought against them, appropriately so. But that's not what we had here at all. We just had a kind of a standard domestic violence order, which I wouldn't want to undermine the jurisprudence there, but this is an entirely different kind of situation.
But, Your Honor, I think what was done here was reasonable, was fair, and the case law, I'm looking at...
Well, let me ask you this. And you, I've always found to be an intellectually honest advocate. So I say that as a compliment, because I recognize that as an advocate. But the question is how would you know where you could protest the actions that are taking place at the military base based upon this order of protection? Where would I know to stand if I came by just reading this order?
Well, Your Honor, I believe you would know, because you've been there before when you got arrested the first time. You go to the same place, you know you're in violation of that order.
Why does this order prevent the defendant from sexually abusing or strangling Mr. Evans?
Well, we wouldn't want to encourage that kind of thing.
Well, of course, but you get my point.
It is
which
a form.
Well, but it's a form where things, I mean, it was deliberately filled out to say to stay away from the school of Mr. Evans. Somebody typed his name in the form there. I mean, what I'm getting at is that both the supporting deposition and the order, which is an order of the court, show extreme carelessness, for lack of a better word. And, these orders ought to give people concrete ideas of what it is they can't do, and there ought to be a concrete reason for why they can't do it. And it doesn't look to me like that kind of care was exercised at all.
Well, Your Honor, this is something that happens every day in our town courts. The judges get a request for an order of protection, and I think the interpretation from this court and other courts is that that should be broadly construed to give protection
But as Judge Fahey said, most of these cases, these domestic violence cases, there's been some act against a person. And it seems to me here that the act is one of trespass. So who's the victim of a trespass? Is it anybody who might be on that property at any time?
Well,
That's part of...
Yes, but I think Colonel Evans qualified as a witness and a victim.
Well,
Did
he see anything that happened here?
I don't know from the October incident where he was.
I thought he testified that he had never seen her before.
He didn't recognize her.
He wasn't afraid.
But, pardon me, Your Honor.
And I thought he also testified he wasn't afraid.
Well, again, I don't believe you should have a being afraid of test.
What is it that he knew? He knew that there were protesters outside? Is that what you mean?
Yes, and one of the things he said, he's responsible for security of the base.
Did he know where the protesters were at any particular time, though?
When these protests happen, he gets notified, and the police respond, and
So for all he knows, the protesters are not on the property. They're across the road and perhaps 100 yards down.
well, once he's notified, he like when this incident, this February incident, he monitored what was going on. And the problem, as he saw it, I think the record supports this, is security of the base and blocking the access. He's not trying to limit particular speech. He's not trying to avoid personal criticism.
Yeah, but the problem is that the order, and I don't know that anything he's got in his affidavit, clarify for the person who's subject to a judicial order and contempt and incarceration and all the rest, exactly where that demarcation is, right? That's the point of the First Amendment, right? So where am I overstepping my rights, or where can I exercise my rights without fear of police action? And I'm not sure the record gives you that, because again, going back to what several members of the bench have already pointed out, you've got this form that doesn't appear to have been intended for this particular type of peaceful political speech.
Well, but it does not go out of its way or directed towards limiting speech. And just real quick, as I'm running out of time, looking at McCullen versus Coakley, the case out of Massachusetts, talked about the government may impose reasonable restrictions on time, place, or manner of protected speech where the content of the speech isn't limited. And so I think that supports our position, and I'd ask you to not grant any relief.
Thank you, sir. Mr. Salisbury?
Thank you, Your Honor. A couple of quick points. In terms of the issue raised in terms of the qualifications of Colonel Evans, I think it's important to note there's nothing in the record that suggests he was present for the October 2012 incident, that he was an actual witness to the crime. And I think he doesn't qualify, if you look at Somerville and Creighton, under that standard.
Was that argument waived when you consented or stipulated to the order, the validity of the order in the trial court?
No, Your Honor. I believe if you look at the record there, I think it's pages 64 and 65, and then 71 and 72 of appellant's brief, you see it was clear the intent on both parties was merely to introduce the order of protection at trial. And in fact, both parties stated that repeatedly on the record.
I understood that whole colloquy to mean that you understood that the court had ruled that it was a valid order, and therefore it was not something you could raise again in that proceeding. Is that,
correct?
Am I correct? Okay.
And the prosecutor even raised that. The court agreed that for the case of the law at the trial level, that was decided. That wasn't an issue for trial. That was
You had preserved your
correct
position with respect to the validity of the order.
Correct. We'd raised that in our motions, and the motions had been denied. So it was preserved, Your Honor. In terms of the...
Can I just ask you, is your position that the form that's in use, it cannot be used at all, or is your position that the form has to be somehow modified to match the facts of the situation presented to the judge? I just want to clarify that.
The form can be used, but it should be modified, and what you increasingly see trial courts doing is providing specificity there, what they mean by stay away. They'll provide definitions. So you see, for instance, in where the two parties are in high school together, they may define you have to be 10 feet away from each other in the hallway, or you have to be seen forms where you have to be on the other side of the street.
So what should the judge have written down on this form? If you're not challenging the use of the form, what should the judge have written on this form?
He should have provided some specificity. I think given the First Amendment implications here, we have the guidelines of Schenck and other cases to provide some specificity of what stay away means here. Because as Judge, I believe as Judge Fahey raised the question, if you just look at this order and show up, you don't know what you can do in comply.
Thank you,
Thank you,
Counsel.
Your Honor.